Welcome to Under One Roof's Landlord and Letting Agent webinar series, made possible through the generous funding of the Safe Deposit Scotland Charitable Trust. The webinar will start momentarily. For those who are joining us for the first time, Under One Roof is a free independent service that supports landlords, letting agents, owner-occupiers, factors, local authority housing officers, and others throughout the sector with issues around owning and maintaining a tenement flat in Scotland. Last year, through funding from Safe Deposit Scotland Charitable Trust, the Scottish Government, and local authorities throughout Scotland, we attained charity status, which has enabled us to hire full-time staff dedicated to working with landlords and owner-occupiers of tenement flats and those that support them. In the coming months and years, Under One Roof will be increasing the information available on our website, our Twitter, Facebook, and Instagram accounts, and through our monthly newsletter. We encourage you to share information we send out with those in your building or in your sector to help us improve the quality of tenement flats in Scotland. Today's webinar will last 1 hour. We encourage you to post your questions and comments into the chat box at the bottom of your screen. The information provided in this webinar is designated to help you understand your rights and responsibilities and to understand what professionals tell you. Any technical information on repairs is designed to help you spot problems with your building and then understand quotations from builders so you can get the best job carried out for the best price. But every building and every group of owners is unique, and so are their problems, which is why the information presented in this webinar can only act as a general guidance. It is not advice or a recommended course of action. When it comes to action, you should always seek professional help with anything more than a simple problem. More details and our legal disclaimer can be found in the About Us section of our website. Finally, if you are a housing professional wishing to record your attendance as CPD, please visit the webinar page on our website so you can log your participation and receive a confirmation certificate. Thanks for joining us. Let's begin. Hello, everyone, and welcome to our first webinar event for 2022. I'm Mike Heffron, the voice you just heard. I am the Chief Exec of Under One Roof Scotland, and I wanted to thank everyone for attending today early in the new year. So we've got a really interesting webinar set up for today on how to use the First-Tier Tribunal. What we're going to be doing is showing you a couple of pre-recorded videos from our guests who will be appearing later in the program to take your questions. First up is going to be Jim Ball. Jim is a partner with TC Young Solicitors in Glasgow. He's accredited as a specialist in housing and residential tenancy law by the Law Society in Scotland and has over 30 years of litigation experience in sheriff court work throughout Scotland. And he generally provides advice on a number of complex issues such as tenant evictions, property factoring disputes, repairs laws, accessing properties, debt recovery, and so on, and is someone that we often go to when we've got questions here at Under One Roof. Jim, incidentally, also sits on as a panel member of the First-Tier Tribunal, though, of course, he's not here doing that. So today he's just providing information for people that are interested in or need to look into going through the First-Tier Tribunal process. But obviously, because of the nature of his role, if you have something currently in front of the First-Tier Tribunal, we won't be able to address questions such as those for obvious reasons that he sits on the panel. But if you have questions certainly around the issue of how to get something ready for the panel and questions just generally about its usage and stuff, he'll be an excellent resource for that. Also, an excellent resource is Alison McDermott. She is a representative consultant for the Property Managers Association Scotland, which is the leading trade organization and association for factors in Scotland, which promotes high standards of property management through advice, training, and guidance. And so she provides a bit of perspective from the factors perspective today. And she will also be here to answer questions as they come up, particularly from that unique perspective. So without further ado, we've got two videos from one I've pre-recorded with each of them, just going through the basics of things, and hopefully they'll be able to not only answer questions you already have, but maybe possibly elicit some new questions that you might have coming out of that, which we'll take a look at in about 30 minutes time. So sit back, enjoy your cup of tea, and watch these videos that we've got. And for you, we'll be back in about 30 minutes to take your questions. In the meantime, if you do have questions as they come up, feel free to put them into the chat room, we have a Q&A chat room and also a regular chat room. But if you can put them in the Q&A, we can load those up as well. And that'll give the presenters who are in the background watching this the opportunity to take a look at them before we get to the Q&A section. So anyway, without further ado, enjoy the videos, and we'll see you back here in about 30 minutes. Jim, could you first give us a brief introduction to the purpose of the First-Tier Tribunal?
The purpose of the First-Tier Tribunal is hopefully to resolve a variety of disputes in the private rented sector and in the sector involving property factors. The tribunal itself is a combination of two previous separate tribunals, the Private Rented Housing Panel and the Homeowner Housing Panel, which were set up at different times under different pieces of legislation, but were combined, I think, in December 2016. And then about a year later, the tribunal also got a whole new raft of powers and duties to deal with private rented sector cases involving things like evictions, tenancy deposit cases, etc. But it's been there for about 14 or 15 years as the Private Rented Housing Panel initially. The Homeowner Housing Panel, which dealt with the factoring, came in about 2012, I think, and then they were both combined in 2016 into the First-Tier Tribunal.
From your experience, what is it that landlords often bring to First-Tier Tribunals as far as disputes?
Landlords will come to the tribunal, I think, for two or three different things. Firstly, they may be brought to the tribunal as the respondent in various cases where you have, if they're a landlord, if people perhaps raising actions against them because of lack of repair, tenancy deposits not there, perhaps wrongful termination orders. On their own behalf, they would certainly raise actions against tenants for eviction, for payment of rent arrears, etc. And also, you have a number of landlords will raise actions at the tribunal in respect of a property factor, alleging the property factor is not complying with the property factor's duties or has failed to follow the property factor's code of conduct. So from a landlord's point of view, there are a number of different potential routes to the tribunal that they may find themselves involved in.
And what we'll do is we'll focus on that last bit today about landlords who are owners bringing actions against property factors. And now, for instance, do you need a lawyer or a solicitor to use the First-Tier Tribunal?
No, you don't. And indeed, the tribunal is designed to be informal and flexible. Indeed, the tribunal works on what's called an overriding objective to deal with the proceedings justly, is what it says in the tribunal rules. And in doing so, the tribunal is required to do various things, one of which is to ensure parties are on an equal footing procedurally, to be informal, to be flexible. And you will find that if you are not legally represented, well, you should find that the tribunal members, and particularly the chairing member, who's the legally qualified member, should be there to not quite present your case and not completely assist you, but to ensure that you're able to present your case. So there's no requirement to be legally represented, nothing to stop you being legally represented. And indeed, certainly in the factoring arena, quite a lot of property factors are legally represented when you have cases against them, but you're not required to do so. And if you are legally represented, then I have to say that the chances of you getting an award from the tribunal to cover those legal expenses is tending towards zero.
Because they're encouraging you. I mean, the whole point of one of the whole points of the First-Tier Tribunal is not to actually have to bring in lawyers. Is that sort of a way of thinking about it? Why they don't give out legal fees and such like that, or is there a different reason?
I think it's just designed that the whole tribunal system was designed to be. It's designed to be speedy, informal, flexible, which I suppose are three things that lawyers are never really accused of being at times. Also designed to be inexpensive, another thing lawyers tend not to be accused of being on a regular basis. Having said that, there are certain cases where I think you'd be well advised, at least not to be represented at the tribunal by a lawyer at some point before you get to that tribunal, to have a fairly serious chat with a lawyer about what's involved in the case, how it should be presented, what are the likely chances of this succeeding, how should it be argued, how should it be presented. But I would certainly say the majority of cases that come before the tribunal, and I am a legal member of the tribunal, the vast majority of cases do not involve legal representation.
And are you able to just walk us through what the steps are to bring a case to the First-Tier Tribunal?
Yeah, it's a fairly simple process. If you go onto the tribunal website, the address of which I can't remember at the moment, but we'll find, you'll find guides to the various jurisdictions the tribunal has. You'll find the various forums you need to complete, and there are actually FAQs, frequently asked questions, which will try and explain things to you. If it's a case against a property factor, then before you come to the tribunal, you are required, in terms of the legislation, to have attempted to resolve the matter with the property factor. You must have used the property factor's complaints process, and you can only go to the tribunal if they have failed to resolve it or have unreasonably delayed in resolving it. Now, that doesn't mean that you have to go through or have a factor setting up a ridiculous process. You could then have a factor saying, well, I've got a 27-stage complaints process, and until you go through that, you can't go to the tribunal. The tribunal has actually had cases where they've said, no, your complaints process has got to be reasonably streamlined and reasonably straightforward. And if somebody is simply just been, hamstrung by your complaints process, they can come to the tribunal. So you've got to have complained to the factor, you've got to have allowed the factor some time to have resolved the complaint, and if you're dissatisfied, then you can apply to the tribunal. But you must be able to show to the tribunal that there is either a breach of the code of conduct or a failure to follow the property factor's duties.
And what, as far as sort of presenting your case, there's a few different options, including oral and paper hearings, I believe. So maybe you could just describe a little bit of the difference between the two.
Yes. The tribunal will take the application. The tribunal goes through a sifting process. It will receive the application. It's looked at by one of the legal members. That member will determine whether or not the application has the relevant required paperwork. There are certain things, as I say, in the factoring case. Have you complained? How did you complain? When did you complain? If it was an eviction case, is there a notice there, etc. So the tribunal member looks and thinks, okay, the required paperwork is there. I'll now send it down the path towards the tribunal, and it's the case is registered. It gets a case number, and the tribunal will tell parties that they're going to have what they call, firstly, a case management discussion, which is meant to be an informal discussion to try to clarify what we actually arguing about here, what evidence do we need, what witnesses do we need, what paperwork do we need. And parties can decide at that stage, or indeed before the case management discussion, that they are happy for the tribunal to determine this on written representations only, or that they require an oral hearing. In other words, a hearing where parties turn up. Well, you don't turn up at the moment, you appear either on screen or on telephone at the moment, but parties have their chance to actually argue a case in front of the tribunal members. So the paper hearing, or the written representations only hearing, will be done based on the paperwork submitted in advance. The tribunal members will simply consider that paperwork, will use what's in the paperwork to inform their decision and make a decision based solely on the written documentation. If you don't want that done, you can proceed to an oral hearing where, in addition to all that paperwork, and the tribunal will look at the paperwork, the tribunal members will be able to question parties, to ask them further information, to get them to explain certain matters, and the parties will also be entitled to try and expand upon the written representations and indeed question each other and almost cross-examine each other at some times if they want to do that. But that's a matter entirely for the parties. If any party wants an oral hearing, they'll get it. And you're not, and even if there's an oral hearing, you're not obliged to turn up. You can actually take the view, well, there's going to be an oral hearing, I'm happy for you to rely on my written representations. I would have to say to you, if there is going to be an oral hearing because your opponent wants one, in my view, you should turn up and be present in that oral hearing as well. I think saying to a tribunal, I'm not turning up, you can rely on my written representations, while your opponent is getting the opportunity to address the tribunal. Is certainly, I would certainly not advise you to do that as a lawyer.
What would be some other errors people make commonly, you think, when using the first-tier tribunal process?
There's quite a lot of errors are made with people in going to the tribunal. I think sometimes one of the errors is that they go too early. They haven't actually allowed the property factor the chance to deal with the complaint. Another error is I don't think they've actually, this sounds a terrible thing to say, I don't think they've actually read the Code of Conduct at times. I don't think they quite understand, what's in the Code of Conduct. I've regularly seen cases at the tribunal where people are alleging there's a breach of this part of the code, and when you actually question them about it, they suddenly realise, well, there's not actually a breach. I'm just not happy at how they've dealt with something. I mean, to give you an example, almost the very first section in the code that you would deal with, you've got section 1 about written statement, leave that aside. Section 2 is about communication and consultation. And in the old code, I know it's been revised recently, but in the old code, section 2.1 says that a property factor must not provide information which is misleading or false. And I've seen cases where I've had applicants come to the tribunal and say, I don't agree with that information. And you're saying, well, it has to be misleading or false. You might not agree with it, but if it's correct, it's not a breach of the code. And sometimes it's not until the person actually sits in front of you or on the other end of the phone from you, and the penny suddenly drops, if that makes sense, that they've realised that's not a breach of the code. And there's various things like that as well. Homeowners must not receive, or factors must not send communications which are abusive or intimidating or threatening. And some people seem to think that there's any sort of letter or email from a property factor which says, if you don't pay my bills, I'm going to raise a court action, that is threatening and abusive. Well, it's not. It's a standard letter that you're going to get. So I think people need to read the code, understand what the code is, and understand that the tribunal can only deal with an application if a property factor is breaking the code or breaching the code of conduct. So just take care, basically, before you lodge the application. Having said that, you will not be shouted at or humiliated or embarrassed by the tribunal. In most cases, what we're trying to do is to get to the nub of the complaint. And in many cases, what you've got is people are alleging 4 or 5 different bits of the code have been breached. And you can actually get them to accept, well, I agree that 2.1 isn't there and 6.9 isn't there, but my real complaint is 5.3, and that's what I want to concentrate on. And I'm quoting these here without you remembering what 5.3 is. But you have those situations where you've got, there's just something is niggling the homeowner or niggling the landlord who owns the property. And eventually, after 15, 20, sometimes 30 minutes, you get them to the nub of the query. And sometimes what you then get is the property factor, I have to say, many occasions in the cases I've done, the property factor will say, I accept that. You're right. I'm sorry, we didn't do that right. We could have done that better. We could have handled your complaint in a different way. We didn't realise that was a complaint. Sometimes they say we thought you were asking something else. And in many cases, you actually get cases almost semi-resolving themselves. And that, I have to say, that used to happen more often pre-pandemic when you had people in the same room. It was much easier to get people to go and have a quiet chat outside, having realised that, and they would come in and say, we've sorted it, we've shaken hands, it's all calmed down. So that sort of resolution is now much more difficult, I have to say, doing these cases by telephone, unfortunately.
And do you find that too? I mean, would you encourage people to look into alternatives before it gets to this level? In other words, look into mediation as a way to resolve these before it gets to the first-tier tribunal?
I would always encourage anyone to try and resolve any dispute they have before they go anywhere near any formal dispute resolution process, tribunal or court. If you can sort it out before you get there, then that's fine. I mean, what I've sometimes said to people at a tribunal hearing is that both of you have turned up today, both of you clearly have a different viewpoint, perhaps, but I'm going to make a decision, or myself and the other tribunal members are going to make a decision, and at least one of you is going to be unhappy with that decision. Sometimes both are unhappy, I have to say, but at least one of you. So if you two can have a chat and you can find a way where you're both happy, that's a better settlement or a better outcome than you might get. Now, in fairness, some folk don't want to do that. Some folk want the decision made by a tribunal. Some folk want to air their grievance formally. They don't feel as though it's been resolved if they haven't done that. So that's absolutely fine. But certainly, I would certainly encourage anyone to take steps to resolve matters informally. The tribunal encourages mediation, but it doesn't have an in-house mediation service. You have to go and do it yourself, unfortunately.
And once the tribunal reaches a conclusion and a verdict, what needs to happen as far as sort of following the court's instructions? Do you have to follow it, or can you appeal?
Well, if you're happy with it, you have to follow it. And in a factoring case, usually we make what are called property factoring enforcement orders, or property factoring enforcement orders. In the main, they are payment orders, I have to say. If you look at the cases on the tribunal website, in the vast majority of cases, what is happening is the tribunal are telling the property factor, make a payment to this homeowner as some sort of compensation for your failure. And the sums are not particularly big, I have to say. They tend to be, in the low hundreds, if I can use that phrase. If you're not happy with the decision, then there is an appeal process. You can ask the tribunal to review it itself. The tribunal can review its decision. You can ask the tribunal permission to appeal to the upper tribunal. There is an upper tribunal which sits above the first-tier tribunal. The first-tier tribunal is required to give you permission or to decide whether or not you are getting that permission to appeal. If the first-tier tribunal grants it, that's absolutely fine. Your case will then be passed to the upper tribunal. If the first-tier tribunal refuses permission to appeal on the basis that we don't think there's a point of law, and it's got to be a point of law, not just don't like the decision, then you can then ask the upper tribunal for permission to appeal directly to it. So you get effectively two bites at the cherry of seeking appeal. Either the first-tier tribunal says, yes, that's fine. If they don't, you can ask the upper tribunal itself to look at it. Again, there's a very convoluted process at the upper tribunal as well at times. If the upper tribunal refuses you permission to appeal without having given you a hearing, an actual oral hearing, you are entitled to what's called a reconsideration hearing, and that must be done as an oral hearing. So if the first-tier tribunal says, no, you're not getting permission, and if the upper tribunal says, no, you're not getting permission, without having given you an actual hearing, you are entitled to a reconsideration hearing in front of another upper tribunal judge. So you could get three bites at the cherry of seeking rights to appeal.
And you sort of hinted at it earlier, but the cases that the upper tribunal actually will hear, do they tend to be sort of the vagaries of specific law? Like there's and there is oftentimes the sort of what is the definition of this word in the context of what we're talking about. So it's going to be that kind of sort of interpretation of very specific sort of things, not generally taking on cases where, like you said, the person's just unhappy with the result.
No. I mean, the upper tribunal is there to deal with appeals on a point of law. In other words, you're saying the first-tier tribunal got this wrong legally. To give you an example, one of the cases that went to the upper tribunal is what is a property factor. There was actually a case against a company, and their position was, we're not acting as a property factor in terms of the definition in the 2011 Act. This was a case, I'm trying to remember this without looking at the decision, this was a case where the company built a block of flats, acted as a developer, acted as a seller of the flats. I think they sold 6 of the 8 flats, but ended up with 2 of their own. And what they did was, they didn't appoint a property factor in the terms that we understand it, but they did the maintenance of the block and they billed the owners. And their position was, we are not a property factor because we are not doing this in the course of a business. And the first-tier tribunal sort of agreed with them the First-Tier Tribunal disagreed and said, well, you're doing it in the course of your business, which is generally being in the field of property. Well, you're not a property factor. You're generally acting as a business and you are therefore caught. And it was appealed, and eventually I think it might even got to the Court of Session, never mind Upper Tribunal, but I think it was Court of Session eventually agreed with Upper Tribunal that they had to be acting in the course of business as a property factor, and thus they were held not to be a property factor. So the cases should be like that. The Upper Tribunal cases should be looking at legal points. Again, other cases that I've been involved in is what is the appropriate method of service of a notice to leave? What's the period of notice? How can you get around the days you need to give, etc. So it should be stuff like that. It should not be, well, the First-Tier Tribunal held this, they decided these were the facts. That's not what I thought, and I want you to overturn it. The Upper Tribunal won't get involved in that. So it has to be a matter of law. In other words, there's something wrong legally.
And finally, what is an example of when you really can't use a First-Tier Tribunal?
In the property factor, or that sort of side of it, what the First-Tier Tribunal can't touch, certainly, one of the things we get asked more than once is, can the tribunal sack or remove our property factor? We don't have that power. We also can't deal with disputes between owners, about the interpretation of title deeds. That's a matter you need to go to Lands Tribunal, Sheriff Court of Session. You have to go somewhere else for that. We don't deal with that. We can't amend or rewrite title deeds. So if you don't like the method of the split of the liability for repairs, we can't touch that either. I say we, First-Tier Tribunal, can't touch that. So there's things that Tribunal can't do. So in the main, in the private rented sector, almost everything comes to the Tribunal now. In the property factor, the ownership side, we deal only with complaints about property factors. Are they complying with the property factor's duties? Are they complying with the code of conduct? Any other argument between owners about who's liable for this repair, what the title deeds might say, can we amend the title deeds, that lies elsewhere. That goes to the courts still.
Jim, thanks very much for your information and your the stuff that you've provided today.
You're very welcome, Mike. Thank you very much.
Alison, could you first tell us how the First-Tier Tribunal works from the perspective of a property manager?
I think that this is one of the key understandings that both property factors and individual homeowners should actually have, is a background understanding of what they're actually becoming involved in. A lot of people don't realise that out there are 400 approximately registered factors managing 690,000 properties. And when they escalate, when a homeowner escalates a complaint to the First-Tier Tribunal, what they're doing is going through a process that will have been discussed to do with the Property Factors Scotland Act and the set-up of initially the Homeowner Housing Panel, which then in 2016 became the First-Tier Tribunal for Scotland Housing and Property Chamber. And when you escalate your complaint into that body, what you're doing is going along with about 200 homeowners a year who do the same thing. When you think about it, 200 compared to the 690,000 properties that are out there is a really tiny, tiny number. And for the Housing and Property Chamber, it's actually a very small percentage of the job of work that they do, because the private rented sector is also part of that Housing and Property Chamber and takes up most of the work that they do. But for a factored homeowner, they will escalate their complaint and it will be picked up by the First-Tier Tribunal and progressed through. And what they will see from their perspective is, what is it that my factor has not done that they should have? And there's two things that a factor has to be doing. One is following the code of conduct, which is part of that Property Factors Act, Scotland 2011. And the other thing that they have to be doing is following their own written statement of service. And if they are doing those two things, hopefully when a case comes into court, it will be found, into a hearing, it will be found that it has not actually been found to be any fault of the factor. That, from a factor's perspective, is obviously what they're looking for. The homeowner is just looking for resolution. So they want a hearing, if it comes to a hearing. They want to have that outcome. They want to be satisfied that their complaint has now been resolved. And the process already discussed and already gone into is what you go through to get to that stage. And on the FTT website, for which links will be provided, there's lots of really, really useful information about what it looks like to go to a hearing, what kind of documentation you'll be asked to answer. From my perspective, the code of conduct is absolutely key. Every aspect of a complaint should be linked in some way to the code of conduct. And that's what a property factor should expect to see when their homeowner comes to them. What did I promise, either in the code or in my written statement of service, I would do that I didn't do? And what have I done about it? And I think we'll come on hopefully to talk about what you should be doing then at that stage.
Well, yeah, we can move right on to that. So what advice would you give to, particularly to people representing factors today that are watching the webinar, on what they should be doing when they are taken to or they have to attend a first-tier tribunal by one of their clients?
I'd say before it even gets to that stage, all property factors should be looking at their own written statement of service and having a real think about what it is they're actually promising. Do you promise to inspect buildings? And if you do, what do you mean by inspection? And have you explained that? When you say that you will respond to a complaint within a specific period of time, do you stick to it? And if you don't stick to it, what do you say to people about it? And do you automatically go in and explain what any delay is? And the reason that those sort of pre-hearing, pre-FTT things are important is because communication is actually the number one thing that causes people to go to the FTT. It might be underlaid by something like a repair that's not happened or not gone right, but ultimately it will involve communication or lack of communication in some way. And the FTT used to, or when it was the homeowner housing panel, used to produce really superbly helpful annual reports that explained exactly how many communication cases there were compared to others. And it's maybe not surprising, you know, human beings do have problems communicating with one another. But one of the things that clearly comes out, and even if you look back on recent case decisions, you see the word communication coming up more frequently than anything else. So what is being communicated? What I see when I look at them quite often is an element of cascade failure, you might call it, where it starts off with being a problem, perhaps about a repair, and it ends up with a fairly significant complaint that involves lots of she didn't get back to me, didn't keep their promises, didn't arrange things when they said they would, didn't keep me informed about what was going on. And that forms a key part then of the complaint. And that's how you can protect yourself. And it's also how you can help discuss with your client as a property factor. Where did we as a property factor go wrong? What kind of things didn't we do that we should have done? Could we have been more interactive with you? And if we could have been, have we apologised for that and have we put it right? Because for a property factor, what's key is not going to a hearing, because it's an expensive thing for a property factor to do. Expensive because it eats up a lot of staff resource, aside from anything else, including if you happen to go on to wish to get independent legal advice, for example. But even actually going to the hearing, attending the hearing, all of the work that you will do in advance of that, there might be more than one actual meeting involved. It's a very expensive exercise to go through. So before you ever get to that stage, have you talked it through, and face-to-face, or in these days on some kind of FaceTime link with your clients is a far better way of dealing with it than allowing it to get to the stage of actually going to a hearing. But once you actually get there, bear in mind that at a hearing, your side of things as a property factor is represented as much as the homeowner. So the homeowner should be going through the code of conduct and the written statement of services that they've got from their factor and saying, here's what my factor should have done, and here's what they didn't do or did instead. From a factor's point of view, it's not really different. They're looking at that exact same thing and saying, where did I go wrong? Why did my communication with my homeowner fail? And what have I done about it? And have I done all the necessary things to stop it getting to this stage of going to a hearing? And if you've satisfied all of that, and you're fairly clear that you have either done everything that you said you would, or you've taken every possible step to remedy the situation, obviously it'll go better for you when it gets to the stage of actually attending a hearing. When you're at the hearing, things to remember are, for example, if there is an assumption made that the title deed is something that, as the property factor, you've signed up to carry out everything it says in the title deed in behalf of the homeowner. That's a fairly common assumption that homeowners make, and it's not actually the case. What have you agreed with your homeowner that you will do on their behalf to make them compliant with their title deed? And have you discussed that with them? Are they clear? Do they understand what they should have been doing? And if it's purely related to issues that are covered in your written statement of service or your code of the code of conduct, have you explained, apologised, taken remedial action to sort things out? All of that will go a long way when it comes to the actual date of the hearing.
I mean, and that's really useful information, Alison. What is, I mean, as you sort of hinted at before, you said that we try to look for opportunities not to have to go to a first-tier tribunal. Another example could be mediation, correct?
Yes, absolutely. And I think what you would recommend, if the relationship between a factor and client has broken down to the extent that the client is unwilling to speak with the factor, then mediation should be the next step. Anything before it gets to a hearing, because hearings don't normally actually solve to anybody's satisfaction the issue that has been raised. Homeowners will frequently feel not enough has been done, and factors will feel unfairly blamed either for things that they've already resolved or that they hadn't the power to resolve in the first place. And it's not always an ideal outcome. Not that mediation is necessarily ideal, but at least both parties to a mediation are agreeing that they will give something to the process. And you can often get a much, much better result. And I think that some links to the Scottish Mediation Service and how to work through that can be provided, so that's the best option. The very first, best, easiest option is for the factor and the individual homeowner to be sitting down and having a conversation with one another in depth about the problems and everything associated with them. But if that's impossible, or things have gone past that stage, mediation is definitely the next best thing, and should definitely be what comes before any hearing every time. Bear in mind what I said at the start, at the very first question, only a tiny number of complaints ever actually get to the stage of there being a hearing. And as a result, it proves that there's an awful lot of intervention already happening before it gets to that stage. So working on improving that situation even further has got to be the best thing.
And finally, what does PMAS offer in terms of additional support or information for people who'd like to find out more?
Well, the Property Managers Association, Mike, is a trade body. Our members are the people that we provide information to. So we can't generally give information to the public. When the public approaches, as sometimes they do, it's because they don't realise that the FTT exists, that this process exists, and we'll point them in the correct direction so that they become aware of that. And what I would say to other property factors, if your organisation is not already a member of PMAS, then definitely it's what to do. As a trade body, we've got loads and loads of experience amongst our existing members who can say, well, this situation has happened to me and this is what I did about it. So there's lots of really good, useful information available in amongst the existing membership that can be shared. And we have a members forum on our website so that we can also share information with the factored homeowners, with the factored property factors who are our members. And I think that's really where we are at with it. The other things that we will do are things like this. Being involved in this webinar allows us to say, well, here's our experience, here's our joint experience as an association that we can share general information about that hopefully will be helpful to people, because when it comes down to it, nobody wants to be involved in this process. The individual homeowners don't want to be at the FTT. They want their problem solved way before then. Factors don't want to be involved in the FTT process exactly the same. They want it fixed at a much earlier stage. And it's those two parties who've actually got it in their power to do that. And so that's where the effort should be placed.
Thanks for having listened to those. And we are going to be joined now by Jim and Allison, whose videos you just saw. Jim's going to be joining us. There he is. Hi, Jim. How are you?
I'm fine. How are you?
Good. And we've got Allison there. And I think Allison's having a problem with her video, so we're probably going to just have her on audio for now, just because of where Allison lives. Hello, Allison. Can you hear us?
I can hear you absolutely fine. I hope you can hear me as well.
We can. Thanks very much for joining us, Allison. Jim, before we get to some of the questions that have come in, and we've got some good ones that have come in, Allison, I thought, made a really good point, actually, and I thought it'd be interesting to hear your perspective on it, is how many of the cases that are brought to the tribunal are issues largely around communication and a breakdown of communication?
I think quite a lot are about breakdowns in communication and about people not understanding, owners don't understand the role of factors, and factors sometimes don't understand the concerns of the owners. And there is a lot of difficulty, or certainly I think lots of the cases I deal with are about problems in communication, difficulty in communication. It's hard to get that across to people on the day. It's just one of those things you just have to deal with. I mean, there's a whole section in the Code of Conduct about communication and consultation. In fact, it's the first section of the Code of Conduct after the one about written statement of services. And it encourages, or certainly requires, factors to be, open in their communication, to use it to build positive relationships, not to be false or misleading, to have procedures to deal with complaints and emails and phone calls, etc. And effectively, I've always taken this view throughout the entirety of my legal career as well. Talking to people is something which is of significant use And I sometimes don't think people actually discuss and try to understand the problems before they end up either running to a court or running to a tribunal. And that's never necessarily the best place to resolve your difficulties. So yeah, I think communication is a significant element of the cases that come to tribunal. And I think, as Alison mentioned, you can go to the tribunal website and you can see all the decisions the tribunal have issued. And I think you can actually search for them. Correct in saying this, it may have changed. You can actually search under the factoring decisions by the section of the code. So you can actually see all the ones that are done under section 2 about communication and consultation.
And actually, just to jump right into the questions here, because I think it's actually very much related, is that we did have one question that was submitted ahead of time, said that if you have been asked to appear at the tribunal, is it too late to try alternative methods such as mediation?
No. And in fact, I might be alone in this, maybe I don't hope I'm not alone in this, but certainly almost every tribunal that I chair, I will ask the parties, is there any scope that you can resolve this today by discussion? That, in fairness, that used to be much easier pre-pandemic when we were in a room together. And you could encourage them even to say, look, if you want 10 or 15 minutes, either you can step outside or the tribunal members will step outside and you can have the tribunal room. 10 or 15 minutes to see whether there's any scope for agreement or some form of resolution between you. That's much more difficult because we're doing them now. And in fact, the vast majority are actually done by telephone case conference, not even video case conference. So it is slightly more difficult, but the answer to the question is no, it's effectively never too late to try some alternative method to resolve the problem.
Alison, is there anything you wanted to add to that?
I think there's nothing really much else to say. I found in my previous life, when I actually was directly doing factoring, going along to hearings, I found them incredibly helpful when mediation, even individual discussions that I would have with my clients at the time were actually encouraged by the panel. There's very clearly a general feeling there that you know, any method of resolution has got to be welcomed there. So, you know, the direct question, is it too late to try mediation? Well, you know, put your mediation hat on and mediate yourself. I think it's definitely welcomed and worth trying right up until you can't anymore.
That sounds like good advice. I've got a question here that came in, and let's see if this might be one for Jim, though. Alison, pop in there too if you've got anything you'd like to add. But the question was this: there are 7 homeowners in the close, all with exactly the same complaint against the factor. We are not allowed to make a joint submission, and each homeowner has to submit an individual complaint on the same matter, which is more work for everyone. We plan that one of us will submit a complaint first, and then if successful, the rest of the complaints will be submitted afterwards using the same material. Is that sensible? We'll start with that one, and then there's a few follow-ups there, Jim, but why don't we just start with that?
Funny enough, I've actually done several cases over the course of my time at the tribunal which have involved multiple complaints against the same factor. And it is, although it's not possible to do a joint or single submission, the tribunal can combine cases and run them simultaneously. And in fact, I've actually got a hearing on Friday involving a group of complaints, all from homeowners in one block against the factor. In fact, if I go back to almost very shortly after the code was introduced and the tribunal or the homeowner housing panel was set up, I was actually the legal chairing member involved in a set of cases that involved 73 owners in a development, all with the same 2 complaints against the factor, one about the land management aspects and one about the property factoring aspects. So effectively we had 146 complaints about the same 2 issues, and what we agreed was that we would take 2 of them as test cases, we would run them and decide them, and the factor agreed whatever we decided would be applied to everyone. So effectively we ran one case knowing there were 73 others, and we did one decision. Now, what that question is asking is, Tally, you can either do either way. Either you all lodge and ask the tribunal, can you conjoin these or combine them? Or you do what you're saying, we'll run one, and if that happens, we get a decision, then the others could then lodge their complaints and say, I've got the same complaint as Jimmy Smith had. Here's Jimmy's decision. I'm looking for the same. I would certainly hope that if it went that way, that assuming a property factor enforcement order was made in the first case, that the factors might be amenable to discussing a similar settlement with the others rather than allowing that to get to the tribunal. But it's in their
best interest.
Yeah.
It's in their best interest, you would think, to do it if the complaint has gone against them, because as Alison had said earlier, a lot of the cost is time. So the complaint theoretically would have to go through these one by one with the other six. So when they're submitting that complaint, should they indicate that, look, there are 6 other people that are going to submit the exact same complaint? Can you consider this ahead of time, or is that something that should wait until the actual hearing is granted?
I think they all have to make the complaint to the factor, and the next part of the question actually mentions a prior notice letter. And I think every homeowner should be sending that letter, because that's the basis of the complaint to the tribunal, the failure to deal with the complaint, if I can put it that way. That letter can be sent in whichever way is acceptable for the factor. It can be sent by hard copy, it can be sent by email, however the factor is happy to receive correspondence. I cannot see any reason why that can't be sent by email. There's nothing in the Act that requires it to be sent in any particular way. And I think in the year 2022, that anyone saying you can't send me formal complaints by email should be frankly just laughed at and ignored, I have to say. I wish I could do that with the Law Society. We have to accept complaints by email. So I've got no qualms at all about saying if they've got an email address, you communicate by email, you can send a complaint by email. No question about that at all. And then there's a bit in this question as well about the submission presented at a hearing. Can they all be done by email? Do they have to be as hard copy? Again, that's more a tribunal thing. And the tribunal is happy to accept representations by email. The documents can be submitted by email. And in fact, the case I have on Friday, I have got, I think, about 700 pages of documentation, all submitted by email, all in sort of PDF format. I'm certainly perfectly happy with that. In fairness, I have to say, in the post today, the tribunal officer just sent me a hard copy, maybe because they think I'm incapable of using a computer. That's probably a problem with the clerks and me rather than in general. But so far as I'm aware, the tribunal's happy to accept stuff by email. And indeed, at the moment, tribunal is doing as much as possible remotely and trying to encourage people to submit by email rather than large bundles of documents. So I don't know if that answered that question to the questioner.
And Alison, was there anything you wanted to add to that, or did Jim pretty much cover that?
I think that's covered. Certainly as far as email complaints are concerned, I've not heard of any factors refusing to accept email complaints.
Okay, another question. Someone asked, do I have to represent myself, or can someone else represent me? Does this have to be another person I work with, or could this be a family member?
The tribunal rules allow you to be represented by anyone so long as the tribunal thinks they are a suitable, a fit and appropriate person, a fit and proper person. The tribunal rules here, I don't think I've got them right to hand, unfortunately. I have only ever, in my entire career at the tribunal, refused one person as being, I think the fit and proper, I think it's phrase used. I can't offend them at the top of my head, find it. But effectively, you can have anyone represent you so long as they are capable of doing so. Doesn't have to be a qualified person, doesn't have to be a relative, it's entirely up to you, so long as the tribunal thinks that they are capable of doing it and are an appropriate person and fall within the terms of the tribunal rules. I won't tell you the situation of one I refused, it's far too long a story.
Okay, another question. I think that's fairly straightforward. If we've got a question from William McDermott. If a landlord who owns more than half the properties in a tenement refuses to agree for shared repairs, can you take them to a first-tier tribunal using it says right to maintain, but the duty to maintain. And they give the situation: there is water coming through the roof as the chimney needs re-rendering, and some tiles are loose. The estimated costs and quotes are coming to about £4,000.
That's not a matter for the tribunal. That's a matter we'd have to sue that other landlord at the Sheriff Court. That's a matter that would definitely go to the Sheriff Court. I think William might be referring to the part in the Tenant Scotland Act that talks about rights for support and shelter. I think section 8, don't react in front of this, but because I'm at home, I don't have all my books in front of here, as I'm doing this by memory. And in fact, there have been various cases at Sheriff Court about that. But effectively, that's a matter for the court. You need to sue in the court to do that. I'm afraid that's not a matter for the tribunal. The tribunal doesn't have that jurisdiction at all.
And Jim, you don't actually have to worry about that. We've got that covered here at Under One Roof. Jazz, who's been helping out in the background, will pop up a link. We've got a section on enforcing repairs yourself.
Excellent.
And there's a number of different options that you would have, including the section on the duty to maintain.
Okay.
And so we'll put that link up. There's a significant section on what you would need to do to send a letter and go through the process of the duty to maintain. So we'll pop that up on the website there and make sure that William gets the information for that. We have I think this was a comment that came in throughout the course of the videos. And this person asks, what do you suggest? They put it in quotes, when the factor simply states no comment when questions come in. Alison, maybe this is one you could tackle first.
So the question is, what do you suggest a homeowner does if the factor just comes back and says no comment?
Yes.
So obviously there's a specific reason for the question being answered. And I suppose here what it comes down to is, in responding no comment, do you believe that the factor has breached either the code or some promise that they have made in their written statement of service as part of their factoring duties? Because, you know, if you get no comment back, then you've got two options. You either accept it or you escalate the situation. So, you know, and if you're going to escalate a situation, you need grounds for escalation. So why has it come back no comment? It's a difficult one to answer without knowing detail of what was asked and what might have prompted the no comment. On the face of it, it can sound fairly damning, but it's difficult to say without knowing more detail about it. But I would say go back to, are there grounds for escalation, and can you find them within the code or the statement?
And Jim, maybe just to follow up on what Alison is saying there, if you talked a little bit about sort of like there needs to be a reasonable complaints procedure followed through the code of conduct of a factor, and 27-step stage is not necessarily going to be considered reasonable. But what about the flip of that when there is no engagement? So in other words, you've got an owner that tries to engage the code of conduct, tries to engage the processes, and there's no response back. Is there a certain point at which you can the tribunal say, okay, you've tried, you just need to have evidence to show that you've tried, there's been a reasonable amount of time for the factor to respond, not a day, maybe not necessarily a year, so somewhere in that spot? But is there a point at which you can bring that to the tribunal and say, look, we couldn't go through the code of conduct process, the complaints process, because they didn't engage back with me when I tried to?
Yeah. I mean, I think that would be that. Without knowing more details of that, if somebody's actually writing to their factor with questions or complaints, and the factor is actually responding saying, I'm not commenting on it, I think that's almost guaranteed breach of the code of conduct, because the code of conduct requires factors to deal with complaints and queries and inquiries received by letter or by email within a reasonable timescale. So if they're simply saying, I'm not responding to your query or your question, then that is a breach of the code. Now, I suppose you technically would have to then write to the factor and complain that you failed to respond to my query, and that's a breach of the code, and allow them to deal with that as a complaint. But again, if they simply say no comment to that, I think at that stage I'd be filling in the forms and going to the tribunal, and I'm pretty certain if that is
simply the situation. I imagine the vast majority of my fellow members would be making orders saying that's a breach, that can't be done, and you should be apologising to that owner, dealing with a complaint, and by the way, here's a property factor enforcement order for a payment of some form of compensation. But again, there may be more in the background to that, and it's difficult to answer, though the question is, the specifics of it, obviously.
Well, we got the.
I think,
go ahead, Alison. Yep.
Sorry, Mike. I just sort of interrupt there. As an example of the kind of questions that can come in, you get occasionally factors will have an owner saying, "I think you make too much money. I saw your director jetting off for a holiday in the sun. What do you have to say about this? Are you ripping me off?" Now, if you get questions like that coming in as a property factor, and they do exist, then potentially coming back with no comment is actually appropriate, which is why I said you have to know more about the background questions sometimes to be able to just blanket answer them. And I would say if there are grounds for escalation, then absolutely follow that process.
What one question that we got in from Christine McLeod was, and this I think came in probably related, Jim, to an anecdote that you were telling in your video. Is it still the case that a landlord who manages repairs for a block of flats should be registered as a property factor? Then that's really a question for the both of you, actually, potentially.
I'm happy to take that first. That does relate to something I mentioned in my question. In the case, it's a case called Proven Properties Limited, which is a case which actually was a court of session decision. I was correct, and I've actually dug that out and I've got it in front of me here. And that was a case where this property company had built a block of flats. They'd sold some off, they still retained some. They had initially appointed the factor, I'd forgotten about that, and then the factor stopped acting. So what then happened was that Proven Properties made the arrangements for the repairs to be done, the close to be cleaned, the roof repairs to be done, etc., etc. And they simply then issued bills to the owners for the split of the cost. They added nothing. They didn't add a management fee, a factoring fee, an administration fee, anything. They simply just split it. And the First-Tier Tribunal took the view they were acting as a factor because they were acting in the course of a business, which was their business as property developers. In actual fact, I was wrong. The Upper Tribunal actually also found that. And it went to the Court of Session. The Court of Session overturned the First Tier and the Upper Tier Tribunal decision. And I think probably the easiest way is just obviously quote from the very last paragraph. And there's 3 different judgments in the Court of Session, 3 different judges go through this. And what they say is that it's not unusual for one of the common proprietors in a tenement, who might, for example, be a dentist, a solicitor, or a grocer occupying the commercial premises, to voluntarily assume responsibility for matters relating to maintenance and upkeep of the whole property. In effect, the same sort of arrangements as in this case. That's something done for the mutual benefit of the proprietors, but the mere fact that such a volunteer proprietor happens to be carrying on a business, in other words, a lawyer, a dentist, a grocer, is not enough to bring them within the scope of the Act, of the definition of a property factor. And the court says that the idea behind the Act is to regulate and register and to deal with property factors, people doing this as their business, as property factors. And the court says that it cannot have been the intention of Parliament that businesses should be treated as property factors simply because they voluntarily take on the burden of arranging certain matters that are necessary for the maintenance and upkeep of properties in respect of which they are an owner in common with other proprietors. Now, the situation that Christine's saying there, a landlord who manages repairs for a block of flats, if that's all they're doing, in other words, as one owner, I'm simply, on behalf of the other owners, I'm making the phone call to the roofing guy to get him to come and fix the roof. He sends me the bill for, I'll try to make this easy, £100, and I split it to 10 ways, and everybody gives me a tenner. That's landlord is not being a factor in terms of the Act. However, if they are, issuing quarterly bills saying, I want £10 from each of you as a management charge for doing that, I think clearly they're then drifting into the property factor definition. And again, it's one of those ones, a very interesting question, and the context of this seminar, I probably don't think to go into full detail, and it might be very worthwhile that person taking some legal advice on whether or not they are going beyond the definition or falling into the definition of the Act and should be registering a property factor.
And that falls in a bit into the area of building associations as well, too, because if oftentimes you will find with building associations, and we encourage people to form building associations and also to have factoring in their building, whether they self-factor or they engage a professional organization. The worst thing that you can do for your building when it comes to factoring is have no factoring at all. But that situation where if there's somebody whose job who sort of collectively has the responsibility to be paying for the lights to get fixed and the clothes and stuff like that, that would be a common thing to do as part of a building association, and something that you would hopefully want, because somebody's got to step up and take that responsibility and stuff like that, and it certainly wouldn't make them a property factor in that situation. So. Alison, we've come to the end of actually the webinar. Is there anything else finally that you just wanted to pop in there before we go?
I would say if there are property factors listening in on the webinar, obviously approach PMAS if you're not already a member. If you are a homeowner out there, either a landlord or other, and you're unhappy with your factor, then absolutely make clear to them that you have read and understood the code of conduct if you are thinking about escalating a complaint, because your factor is then totally aware of where you stand as far as your understanding is concerned. And that may help them, because it helps focus on what it is you think that they've done wrong, and it helps them respond. And ultimately, if it does end up with a tribunal hearing, it actually helps at that stage as well, because everybody's very clear about what everybody else thinks has been breached or not.
Well, I want to thank both of you, Jim and Alison, for taking part in the next the webinar that we had today. We've got plenty more coming up. Speaking of next, we've got one coming up at the end of the year. That'll be a general Q&A, something we do every month here at Under One Roof. Well, a chance for owners and landlords that are owners, and also property professionals to ask questions of our expert panel. We always bring in Annie Flint and John Gilbert and myself, bring in those questions and get you answers to them as they come. They can be on any subject that Under One Roof works on. So we'll be having that. That'll be coming up the last Tuesday of this month. And then coming up in February, we've got one on coming up on historic renovations, if you got renovations in a historic building. So, but we'll have more on that. We'll send you more information on that. I'd like to thank Jim and Alison for taking part in the both the videos and in the Q&A today. Thanks very much, both of you, for joining us today.
Thank you very much. Pleasure.
Thank you very much.
Great. And enjoy your first part of January, and we'll see you back here in a couple of weeks. Thanks very much.